I'm Steve Huffner, the Deputy Director of the Election Law Program at The Ohio State University. And I'm delighted to be here for another episode of Law and Democracy and to be joined by my OSU colleagues, Ned Foley and Terry Enns, and our special colleague, Tony Goggin, who's visiting with us here at Ohio State this fall. I know we've had several good discussions in previous episodes, and I'm looking forward to whatever we are able to work through together today. So Tony, tee up a question for us.
Sure, Steve. Our first topic today is from the state of Georgia, which has certainly been in the news in the last couple of weeks when it comes to election law developments. The latest is the Georgia State Election Board's new rule that they issued last week to force the state's counties to hand count all ballots cast on election day. The change, of course, comes on the heels of a new rule that the board issued last month to empower local election officials to conduct a quote unquote reasonable inquiry into elections before certifying the election results. Lawsuits have, of course, been filed to challenge the new rules. So our first question is, what do we make of what's going on in Georgia?
Just to clarify, Tony, I want to make sure that I understand what is counting what. So it's a hand count of the number of ballots to make sure that it matches the number of votes cast in the machine. Is that correct? So that if there were just the 200 ballots here, there's got to be 200 ballots here. And that's what's being hand counted, right?
That's my understanding.
Yeah, it relates to a long-standing policy called reconciliation, which is part of the canvassing process where local precinct officials and election workers are supposed to make sure that the number of votes cast matches the number of voters who actually, signed in the poll book in order to be able to vote. And so it is introducing a hand count of a procedure that otherwise could be tabulated by machine, at least the ballot part of it.
And certainly at a minimum, it reflects a suspicion of the machines that's emanating from the election board itself, which certainly appears to be an unusual source for questions about the accuracy of the machine count.
Yeah, I mean, what's going on in Georgia is unexpected would be one word for it, I think. Partisan would be another word because the board is splitting along party lines, as I understand it. And unfortunate might be a third word in the sense that this is happening so close to the voting process and causes confusion and destabilizing. I think the good news, and hopefully the main message, at least that I'd like to convey, is that I think this will be a hiccup that won't really derail the electoral process in Georgia. I do think the courts are going to make sure that the system works properly and that the results are all achieved in the time frame that they need to be, whether we're talking about the reasonable inquiry rule or the hand counting rule. These rules are administrative and can be overridden by state statutory law. We could talk about that some more. But I think also officials like Secretaries of State Raffensperger in Georgia and other officials are going to make sure that that nothing goes awry as a result of this hiccup.
I just was going to ask, practically, it will potentially slow things, right? Just because it's an extra step, but it doesn't have to be more than that, right?
Right, and I'm not sure, again, we can get into the details on this, but there's a legal procedure called a writ of mandamus that can force local officials to do what they're required to do, and state law in Georgia requires certification by a date certain. And I think if if there's any risk of that deadline being missed, or as soon as it is missed, I suspect the mandamus request for mandamus will be filed immediately. And I think that could even be supported by the Secretary of State. So um, uh, yes, there may be a little bit of delay as a result of this, but hopefully not any major delay. Steve, it sounded like you wanted to jump in.
Well, I was going to say that most of the election officials from the state level on down have not supported this, but at the same time, I think they're prepared to do it and to do it as efficiently as they can. And it does seem like there ought to be time to do this manual reconciliation, if you will, within, I think it's a week that Georgia has between election day and when their statute calls for certification to occur. Unless some actors start getting involved in really using this new hand reconciliation requirement to deliberately gum things up. And, that's always a risk. And so from some quarters, we've heard concerns that there will be a risk of delay. I think I share your optimism, Ned, that the officials, including the folks at the local level that have to do this, are going to be able to do it within the time that's available to them.
When you say gum things up, Steve, do you mean sort of legally gum things up so that from a rule of law perspective, there's a deviation from what the law requires? Again, it may not be ultimately consequential, but still it's a legal error or legal problem. Or do you mean gum up in the sense of this becomes political fodder for trying to instill distrust in the process? Because I could imagine a scenario playing out that the courts order compliance with the relevant statutory deadline, which means that this new hand count, can't be completed, even if it started, at which point, again, from an integrity perspective, there's really nothing wrong because the hand count wasn't necessary in the first place and wasn't legally required or even authorized by statute. But if the hand count got underway and then got stopped, you can imagine people complaining, "Oh, this shows that that we don't have the true result, and the court stopped us from learning the true result," and we could get kind of conspiracy theories that cast doubt over the process in a way that isn't deserving to be impugned like that.
I think your latter possibility is the more likely one. I mean, the former possibility, which you described as more of an actual legal gumming up, would really depend on courts not performing the role that you had articulated a minute ago, right? If courts are ready to step in and using the statutory requirements, insist that the deadlines be adhered to, then the only risk really is the way in which the Georgia results might be impugned in the minds of the public. But there still is some risk that as a legal matter, not everybody's going to see the legal terrain exactly the way you described, Ned.
Yeah, no, that's a fair point. I guess, I mean, my general overriding take on this is the law should be followed, whatever the law is, even if I don't like the law. And so, if it were legally permissible for this state board to do this, even at this late date, the rule has to be followed. And if it caused so much delay as to threaten Georgia's participation in the electoral college process, that would be really concerning because there's a hard federal deadline of December 16 by which Georgia's electors have to be appointed. there's some intermediate deadlines along the way, but that's the real hard deadline under the system. But I haven't read or heard anything that suggests that, as unfortunate as this development is, that it's realistically going to jeopardize Georgia's ability to actually appoint electors and therefore participate in the electoral college system.
I share your optimism, Ned, in part because Georgia's been here before. They went through the 2020 experience. They went through the US Senate runoff elections, which I think were in January of 2021. They also had a very contested Senate race in 2022. If this had happened 10 years ago and Georgia suddenly went from being a red to a purple state, I can imagine a scenario where it might catch election officials off guard, maybe even the judiciary. Whereas because Georgia's gone through this, I think that the responsible actors in all respects, the election administration, the judiciary, and elected officials are very well prepared for what the issues are going to be. And being prepared, I think, helps under the intense pressure, the time pressures, political pressures of dealing with any kind of election controversy coming out of November 5. So that's and I might add, I think Georgia performed really well in 2020. The system that overall in the United States, I think, did really well through that election. But I think Georgia's performance was particularly impressive in light of how close the race was in that state in 2020.
Yeah, I agree with that.
I will echo something you said earlier, Ned, about how unfortunate it is that this hand counting or hand reconciliation requirement has come this late in the process. And it really is an 11th hour change to the processes that the election officials are all geared up to conduct. And so, they still have, yes, 6 weeks or so to be prepared to do this. But given the range, not the range, but given the long list of other things that they need to be doing in managing the whole process, which is already underway for military and overseas voters in every state now, it does complicate their life. And I can sure imagine election officials themselves chafing a little bit at this, or more, tearing their hair out, if you will.
Is there a chance that it adds one little layer of transparency that makes other fights less likely?
I really like that question because I think it turns around the conventional narrative in a useful way. I generally think more transparency tends to be better. I mean, and we have such a trust deficit in the electoral process, not deserved, but it exists, and it's dangerous to have this degree of distrust. So anything that could improve trust is welcome. And so even if this is a late change, and even if it's unnecessary, if it actually assuages people and says, okay, I guess we can't complain because the numbers are the accurate numbers, that would be a good thing. So
yeah, if the machines aren't eating ballots, or not if they're not failing to count things that they should be counting, then hopefully that gives some people a little bit of comfort that the numbers are the numbers that are accurate.
yeah, I mean, I really like that point. I mean, obviously this change has been resisted by people who are knowledgeable and care about accuracy. So I do think it's still unfortunate that I agree with Steve, this last minute change was demanded and implemented. And so I'm reluctant to add extra layers that can also be counterproductive in terms of adding delay and so forth. But given where we are, if it actually produces more trust, then let's take a victory on that point, which we desperately need in Georgia as well as elsewhere.
one concern I have heard voiced is that the hand count introduces the element of human error, because presumably with millions of votes being cast, there will be hand tabulations that get it wrong and then have to be rechecked. And then that tabulation, the original tabulation, will probably be reported that there's a disconnect between the hand count and the machine count. But this is also a situation where, because people are on notice, I certainly would expect that Georgia election officials will be very quick to address any reports that there is some sort of problem with the hand count, that it's reporting different results. I would also assume we're not going to be, even if the hand count's erroneous, it's not going to be a large number of votes that are involved. So it shouldn't be sufficient to sustain any kind of conspiracy theory about the election. But I do appreciate the concerns of election officials that we are going to have an element of human error here that we wouldn't otherwise.
Yeah, that's true. And you put your finger, Tony, on what I think is important, which is every election has, some modest discrepancy in the numbers just because it's a human enterprise. But in an election where the margin of victory is 10,000 votes, which is both a very close race in a statewide election with millions of vote cast, and yet 10,000 vote margin is not 5 votes or 6 votes. So, discrepancies in numbers in the tens or, even hundreds, it doesn't impugn the validity of the result. And I think reasonable people being told that in one sentence would well understood that point. The thing that worries me is, and I hate to say it, is one of our candidates is well known for distorting the truth and often just fabricating things and taking things out of context. And so, if there's an error, even of the magnitude of only 5 votes apart, that candidate will say the numbers don't add up, and there'll be a lot of citizens who don't, who are not election experts and don't hear the extra sentence. Well, the way in which the numbers add up doesn't really mean anything from the integrity point of view. They'll just hear the numbers don't add up, and they're told that something's wrong. And so, we're back to a situation where there's no reasonable ground for distrust, but the distrust gets developed anyway.
I think it's important to note that we've never had perfect elections. There have always been elections in which this reconciliation process produces discrepancies. And the point is not to use this process to have a perfect election. The point is to use this process to just confirm that we didn't have rampant ballot box stuffing. You can have an election in a particular precinct where you have 612 votes counted and you have 610 people marked as having shown up to vote. Does that mean there were 2 fraudulent votes cast? Not likely. It means that the human error occurred at the point of marking them having arrived to vote. And when the errors are that small, they're more than tolerable. They're to be expected. There were times in most states when, if you had a discrepancy between the number of people who were marked off as having shown up to vote and the number of votes actually cast and counted, and if that number of counted votes was larger than the number of people that the poll book showed had voted, there was a random withdrawal of votes from the count so that the total count of votes cast matched the number of people who presented themselves. There are still, I think, a few jurisdictions who do that. I'm not enamored with that solution. I think that is more likely to lead to disenfranchising legitimate voters whose votes are withdrawn randomly when they were entitled to vote and just not properly accounted for. But in the circumstance in which a certain precinct has 100 extra votes compared to the number of people who presented themselves, that would tell us something important. I don't think we're going to find that.
Right. You know, a theme that you're all familiar with in terms of my thinking is this concept of good faith. I mean, if everybody involved in the process recognize that elections are competitive, one side's going to win and the other side's going to lose, but we all try to follow the rules and do this for the sake of the whole community. We understand that point, Steve, and we live with it, and we still declare the winner and respect the winner because we know the system as a whole is working authentically. But in a world where that basic element of fair play is not accepted, then even if we have a good election, it may not be accepted as a good election. And I don't know if there's anything as a legal matter we can do about that other than to call it as we see it and say, yep, we've got a valid result, whether your team wins or your team loses, but the result is valid and we all should accept it. I think whether we're talking Georgia or any of these battleground states, if it's really close, I think there's going to be some effort to impugn the result, whether the basis for that, there's any valid basis to do so or not. And again, at this late date, I don't know there's anything more that we can do, but just run the election and hope for the best.
It is a paradox of our times that election administration is more professional today than any time in history, and yet there's more distrust of it. And Ned, certainly your scholarship speaks directly to this with your book, Ballot Battles, that we've seen many instances in the past of really serious problems with election administration, but it didn't have the lingering effect of undermining public confidence like what we're living through in the 21st century, when that lack of public confidence is much less justified today than it would have been in the 19th century or other points in our history.
Yeah.
And I'd say not only is election administration more professional today than ever, I'd also say that it is more transparent and more observed than ever.
True.
It's also more broadly accessed than ever. You know, we've done a lot with helping persons with various kinds of disabilities be able to vote. And so there's so much trajectory in the right direction that it's kind of dismaying when we take steps backwards. And it's hard to figure out when and why. You know, I wonder, and Ned and Steve have heard me talk about, why do we need the election results on election night? Like, if we slowed a bunch of things down, and would that lead to some different processes that people would trust a little more just because they understand them better than they do the machines and how the machines work? I don't know. It's hard to go to anything more that's slower now. So I'm not making that as a proposal. I'm just saying I think that's one of the places we've gotten caught.
I presume that this hand reconciliation process in Georgia is not delaying the reporting of the unofficial results. Is that correct?
I would think that's correct.
Yeah, I don't know.
And of course, we've talked today extensively about our hope and assumption that it's not going to delay the certification that's official a week later. But, you know, I think there's still some misunderstanding out there. And this circles back to where, Terry, you began today, which is to observe quite carefully that this requirement is not a requirement that the vote tallies in each race for each candidate be hand counted. It's just a requirement that the number of ballots that are actually cast be hand counted to see that they match the total number of people that we expect to have cast a ballot based on who presented themselves to vote. that too could have some error with it, as you said earlier, Tony, but it's a different kind of error risk than hand counting of the vote totals, which election officials have known for many years produces less accurate results than electronic tabulation of the votes cast. And there are still a few jurisdictions, they tend to be the very small jurisdictions, but a few small jurisdictions in scattered places around the country that are hand counting the results of their races. And this is not requiring that. So again, I think there's reason to be hopeful it's not going to create major problems.
And we talked about this a couple weeks ago, but the state timing laws should trump, right? Should be.
Yeah, that's what Ned was.
Those deadlines must be met, and that's why you were talking about a mandamus, where a court could step in and say, it must be done. Here's how it's going to get completed. So, yeah.
Terry, to one point that you made about timing of unofficial returns on election night, I don't think this point applies specifically to Georgia, but I'm thinking more directly about Pennsylvania in that if Pennsylvania is close, as it's expected to be, we're very much unlikely to know, even unofficially, who won Pennsylvania on election night. And I think the public needs to be ready to expect that it could take, days to know the outcome of Pennsylvania, and as it did in 2020. And if Pennsylvania ends up being pivotal, the whole election could need to wait until we have an answer as to who wins Pennsylvania.
Yeah, I just think it's important that we keep saying that that's because the system is working, not because something nefarious is going on behind the scenes. No, we're waiting for all of the validly cast ballots to be accurately counted, so that we've got the clear result. It's not that somebody's trying to make ballots behind the curtain or something, but I think we need to keep saying that.
On that point, and I know this isn't the direct topic of our today's conversation, and maybe we want to come back to it, but on the day that we're recording this, my understanding is the Fifth Circuit Court of Appeals is hearing an important lawsuit about whether or not states can allow, as many states do, ballots to be postmarked on election day, but returned subsequently. And this novel claim, given this practice is longstanding among some states to allow for absentee ballots to arrive after election day, as long as they've got that postmark by election day. The novel claim is to challenge that as a violation of federal law. My own instinct is I doubt that will be successful, having looked at the briefs in the case. But I haven't heard a report of the oral argument yet, and of course, until we see the court's decision, we don't know for sure what the answer is going to be. But if that lawsuit is successful, it will, significantly change practice in many states, and would be another ruling very close to election day involving absentee voting, which is getting underway already. And so I think we should keep an eye out on this Fifth Circuit case until we get the ruling of it.
Yes, definitely, Ned. And speaking of late-breaking developments in battleground states, we have a late-breaking development, not in a battleground state, but in a battleground congressional district. As you all know, Nebraska and Maine are the only two states that do not award electors on a winner-take-all basis. And in Nebraska, Joe Biden lost the state in 2020, but he won one of Nebraska's 5 electoral votes. That was the electoral vote associated with Nebraska's congressional district in Omaha. This year, there are a number of scenarios in which the 2024 election outcome could be determined by Omaha's single electoral vote. But in recent days, the Republican governor in Nebraska and the Republican-controlled legislature tried to implement a last-minute switch to a winner-take-all system. Today, however, this afternoon, the Nebraska governor announced that he would not call a special session because at present they do not have enough votes. Even though the Republicans have a majority, they don't have enough votes to switch the system to a winner-take-all system. So the first question is, certainly Nebraska has the constitutional authority to determine how it awards its electors, but does this effort to change the rules late in the day raise any concerns, particularly with regard to how the Electoral College plays out in different ways in different states?
So you're absolutely right, Tony, that each state can decide how it wants to award its electoral college votes. And Nebraska is one of two states that presently do not use winner take all means to determine who gets their electoral votes, Maine being the other one. And there's a way in which in recent years, Maine and Nebraska have kind of balanced each other out in that regard. And the effort to shift Nebraska to a winner take all system was not a new idea. I mean, it's been talked about for a while. And in fact, the Nebraska legislature was heading in that direction much earlier this year and couldn't come up with the votes then either. But at the time that that conversation was occurring, there were other conversations occurring about how Maine might be required to respond in kind. And if Nebraska went to winner take all, that Maine would then go to winner take all to keep the balance, if you will. The closer we get to election day, the more efforts to switch what a state has decided it will do to award its electoral college votes looks like manipulating the system to generate a particular outcome of this election, rather than having a predetermined system that has been adopted by a state on the basis that the state thinks it's a fair system, regardless of candidates, regardless of voter preferences, if you will. So the closer you get to the election, the more it looks like it's a short-term political gamesmanship that's being played, I think.
And just to build on that point, my understanding of the timing in terms of the relationship of Nebraska and Maine is that in Maine, just because of the circumstances of the specific state law, no change could be made within a 90-day window of election day. So Maine could have done a tit for tat as long as it was prior to that 90-day window closing. So the reason why this renewed effort in Nebraska got a lot of attention recently, including members of Congress and Senator Lindsey Graham trying to really pressure, I think it's fair to say, the Republican members of the state legislature on this point, was because the 90-day window in Maine had closed, which meant that if Nebraska had gone forward with this change, the retaliation, if you will, to even it out on a partisan basis wasn't an option. So it was especially aggressive gamesmanship to try to do this at the last minute, really, because Nebraska didn't have the same kind of strict 90-day window closing that Maine had.
And that raises the question, I think the answer would be yes, but would it be constitutionally permissible for Congress to require states to determine what electoral method they're going to use in an election by a date certain? There's certainly a date by which they have to report their electoral or conduct their election. But what about a statute that it's a deadline for the electoral method that states are going to use? Would that be permissible?
Great question. I think so. Article 2 gives Congress the power to choose the time that the electors are appointed. And I think encompassed within that under using the necessary and proper clause as the ability of Congress to pass laws that facilitate other powers that Congress has, I would think it would be pretty straightforward to say that because Congress wants a fixed time by which electors are chosen in all of the states, it can also mandate a specific time by which the method for appointing those electors is also settled. So I think that would be within congressional power. And might be a very good idea in light of what we've just witnessed.
Certainly, we think it would get bipartisan support.
Yeah, I get right. I mean, because again, assuming we survive this year's election, who knows what efforts there will be to reform the electoral college system, either writ large or tinker with it. But this is by no means the only way this game can be played. As Tony, as you well know from your own work, in the early years of the Republic, states did this kind of back and forth. In the monumental election of 1800, the state of Virginia switched its method and went from the kind of district-specific method that Maine and Nebraska uses, maybe not exactly that district-specific, but pretty similar, to a statewide winner-take-all in order to make sure that Thomas Jefferson got all of Virginia's votes and not just some of them. And the thought was that New York might do something different, but John Jay didn't want to play that partisan game in New York. So, different of our founders acted differently with respect to manipulating the process. And there have been moves made, never successful over the last 10 or 20 years, where Pennsylvania might switch from winner take all to district to kind of divide up that state's electoral votes. Michigan did this back in the 19th century and won a Supreme Court case which allowed it to switch from one system to the other. It didn't work, but it was the same kind of game. What I think, I'd be curious as to all of your thoughts on this. I think as a country, we got used to electoral college landslides in sort of the middle to the late 20th century. Even in elections that were fairly close, they weren't knife edge elections the way we started to see with Bush versus Gore in 2000. And so when there's these broad swings from one party to the other, when Nebraska and Maine, relatively small states with few electoral votes, decide they just want to do something different, nobody really viewed this as pernicious or inconsequential. They thought it was kind of cute and quaint that these states would kind of go their own way. But in moments of high polarization where every electoral vote counts, as it did at the end of the 19th century, as it did at the beginning of the 19th century, and as it does now, it's not so quaint anymore. And you wonder whether or not, in addition to your statute, Tony, which is a great idea, which I think Congress does have power for, it would almost be nice if there was a nationally uniform method. But that, I think, would be beyond the scope of congressional power, given that states definitely have the right to choose their own method. But this exposes what I think are fundamental structural flaws in the electoral college system, that the freedom of states to do what they want can have partisan consequences, because even if Congress set a deadline, states could some states are in a better position from a partisan perspective to act in this manner. If one party controls the governor and the legislature of the state, they've got the so-called trifecta, which lets them impose their will, whereas other states have divided government and can't do it. So the ability to do tit for tat can vary from state to state and from year to year.
Yeah, I think
I wonder if you asked 100 people what percentage would know that the electoral college votes are not generally awarded proportionally? I mean, I think it's not instinctive. Well, electoral college isn't instinctive, and then how it works is not instinctive. And I think there are a lot of people who assume that they're awarded more proportionally, not just 2 states. It'd be interesting to ask sometime.
Well, and on that point, I think there are many people who would argue that Maine and Nebraska are doing what is a better thing, that, that is more proportional to their state's voters. And that the 48 other states and the District of Columbia that are winner take all are using a less desirable system. But as Ned was observing, no state's going to have much of an incentive to move from winner take all to district based or proportional based selection of its presidential electors. The winner take all dimension of it becomes even more concerning, as Ned has written about extensively, when a state is going to award all of its electors to a candidate who did not even get a majority of the vote in that state and simply garnered the plurality of the votes cast in that state. But that's where we are. And so there's lots of room to think about reform, adjustments, but nothing easy.
One thing troubles me about the specific way that Maine and Nebraska do it in terms of awarding some electoral votes by congressional district is that if you have gerrymandered congressional districts, then the presidential election process also reflects that gerrymandering. I do think there's ways to do proportional allocation of electoral votes on a statewide basis that doesn't involve gerrymandering, that arguably would be a fairer method, especially if all states adopted the same method. But yeah, I mean, unfortunately, given the electoral college system, there's no great way to operate the electoral college if you think we shouldn't have it in the first place. Obviously, we do have it, but when it gets ugly like these last minute changes, that seems to be especially abusive of the system.
I think it reflects how one's view of the benefits or the detriments of an election law during a time of polarization is deeply influenced by whether your party benefits from it or not. I think certainly the electoral college is more unpopular now with Democrats because of the fact that Republicans are able to get to 270 without winning a majority of the popular vote. But if you look at population trends in states like Montana and Idaho, if you look ahead to the 2030s, it's entirely possible that Democrats will have a majority, thanks to the growth of Bozeman and Billings in Montana and the growth of Boise and Idaho, because they're low population states. It doesn't take that many people moving in from California and elsewhere to flip the politics of this state. We certainly saw that in Colorado 30, 40 years ago, in Oregon. And so it'll be very interesting if the Electoral College a decade or two from now works to Democrats' benefit and hurts Republicans if Democrats don't start embracing the Electoral College and Republicans don't start to see it as a real problem.
We may get, I mean, it's more likely that if we get a discrepancy between the Electoral College outcome and the popular vote outcome, that it replicates what we saw in 2016 and 2000, where the Democrat wins the national popular vote and the Republican wins the Electoral College majority. But it's not inconceivable, as I understand it from the prognosticators like Nate Silver and Nate Cohn at the New York Times, that we could have an Electoral College inversion, as they call it, in the opposite direction this year, where the Democrats could win the Electoral College and the Republicans win the national popular vote. And if that happened, then I do think the politics, might open up the possibility for serious reform because, I would hope that the Democrats wouldn't backtrack on their desire to eliminate the Electoral College. And then if the Republicans came on board in not liking the Electoral College, is it naive or idealistic for me to think that you might get a sufficient national consensus for change?
And certainly
That-
the Republicans won the popular vote for US House in 2022. And they only won something like a 9-seat majority, even though off the top of my head, I want to say they won the popular vote by 3 million. So there is a recent precedent for Republicans carrying a popular vote, as it were, nationwide.
And this almost happened in 2004 when John Kerry came very close to winning Ohio as the pivotal state. That would have been Democrats winning the Electoral College majority, but the Republicans winning the so even given that 2000 the inversion went the other way, this country is such on a knife's edge, both nationally and the Electoral College, that the inversion could go either way, as I understand it.
Now, Ned, I had seen some reporting a couple of weeks ago about this year having a sort of real possibility of that inversion running the other way. But I haven't seen that in the, I mean, are people saying that at the current moment? And I know the polls are going lots of directions and, there's a lot of volatility. And so if it could have been foreseeable 2 weeks ago, it's foreseeable now, but I just haven't seen recent discussion of that the way I did a couple of weeks ago.
Well, the most recent that I saw was in the New York Times had this poll that some people perceive as an anomaly, which, if I understand it correctly, is it showed Trump doing very well nationally, and Harris doing very well in Pennsylvania. And so one explanation is that's just an outlier poll. But Nate Cohn of the New York Times, now maybe he's trying to defend his own poll, but his role is to analyze all the polls. And he was making a case for saying that this could be a signal that this inversion is not as unlikely as some people think. So that's I think that poll came out over the weekend, so that's relatively recent, I think.
Yeah.
And certainly 2022 was an example of that, in that because the Republicans won the popular vote by such a huge margin, where in the past they'd lost the popular vote for US House nationwide and still won a majority. This time they won a huge popular vote majority nationally, only had a small majority in the House. And the explanation for that, that I understand, is that the Republicans, because they're expanding their base among working class voters, including working class voters of color, their margins in places like California that they lost by were much closer than they'd had been historically. And so that's an indicator that Democratic strength in blue states may be shrinking, and then that increases the possibility that you could have an inversion of the Electoral College popular vote majority going in the opposite direction.
Right, absolutely. If Trump does, pretty well in California, upstate New York, downstate Illinois, and rural areas of blue states, not enough to win those states, but enough to come a lot closer. That's a lot of national votes that don't affect the Electoral College outcome. So, yeah, we may be, who knows what surprises we may in for. I'm sure we need to wrap up in a second, but coming back to the Nebraska point, I'm very glad that this particular issue is settled, and that, again, we aren't seeing a last minute change. Whether you like the rule or not like the rule, I think these changes shouldn't happen at the last minute. But I still am worried about the predicate for this. As you said, Tony, at the outset, the reason why people are talking all about this is the real possibility that the result ends up being 278. 270, the bare minimum for an Electoral College majority, versus 268. And, you know, if that is the way it is, that means every electoral vote matters, including the ones in Maine and Nebraska, whichever way it goes. And I just think in our very fraught environment, I mean, it is what the law requires, and it will be the legal result, but I think it will be harder for the country to accept an electoral college victory that is so narrow, especially if it's one of these inversion situations, whichever way it goes. So again, there's nothing we can do about it. The system is what it is, but we will have a lot to think about and talk about if it turns out that the result is that narrow, I believe.
Well, Ned, as you observed, we've about come to the end of our time together today. But before we wrap up, I know, Tony, you've got a new trivia question for us and an answer to our last one.
I sure do, Steve. Just as a reminder, our trivia question for this week was, what was the election law issue that plagued Bobby Kennedy throughout his 1964 Senate campaign in New York? And the answer is, Bobby Kennedy could not vote in his own Senate election in New York in 1964 because he did not meet New York's voter registration requirements. In 1964, New York had a 90-day residency requirement to register to vote. At the time, Bobby Kennedy was the Attorney General of the United States in Washington, D.C., and he jumped into the 1964 Senate race late. He did not even arrive in person in New York until the last week of August 1964, when he rented a home on Long Island. That was only about 75 days before Election Day, so he was not eligible to vote. However, he was constitutionally eligible to serve as a senator from New York. Article 1, Section 3 provides that a senator shall, quote, when elected, be an inhabitant of that state for which he shall be chosen. Kennedy was living in New York on Election Day, November 3, 1964, and he defeated the Republican incumbent Kenneth Keating with about 54% of the vote, and then he took his seat in January of 65. Interestingly, however, he still didn't buy a home in New York until the spring of 65, which is when he registered to vote in Manhattan. So that was this week's trivia question. Our trivia question for next week is this: where did the lion's share of Abraham Lincoln's campaign funds come from during his 1864 presidential reelection campaign? Where did Lincoln get his campaign funds primarily from when he ran for reelection in 1864? So stay tuned to find out the answer to our latest trivia question.
That's great. Thanks, Tony. Well, and thanks to all of you, Ned and Terry and Tony. It's great to be with you again, and I'll look forward to another episode of our Law and Democracy podcast. Until then, be well.